Hello friends, how are you? Today I am going to discuss an important update concerning Drugs and Cosmetic Act. If you are a doctor or a registered medical practitioner, usually the concerned drug inspector inspected the premises of you and inter alia book you for the violation of section 18 subclause C of Drugs and Cosmetic. The primary key is that we are not aware with the legal position. We may be, but the concerned drug inspector, who is part and parcel of the state agency, by overlooking the provision of law, inter alia intend to book us. And if such prosecutions are allowed, and we are compelled to face the trial in such bogus litigations, in that scenario, our rights are going to be affected. For example, if you are innocent and you are compelled that you have to face the bogus case, will you face? Answer is no, na. So when you could not, then you have to be ready with the legal provisions. You have to move at the first instance before the Court of High Court. If the concerned Court of High Court inter alia refuses to accept your contention, inter alia fails to quash the proceeding, then move to the Supreme Court as observed in the present case, which I am going to be discussed with you. It is an eye-opening case for every medical practitioner, because whenever you are going to book, you kept silence that we cannot fight, we cannot make the objections, we have to face the trial, otherwise we have to face the dire consequences. No need to worry, I am here with you. You just have to understand the basic provision of law, and if you are having the same problem, just enforce your right as per law. Basic is that if you are not having the knowledge of law, such type of people who are totally inter alia ready to make the mockery of justice will play with you, will play with your rights, will play with your emotions, and inter alia they will have to teach a lesson in the court of law that if you are going to break the law, if you are going to violate the law, if you are going to make the mockery of law, the literate, the eminent persons are also available who could definitely contest with such the intentions. So basically we have to understand the law, we have to understand the basis of legal provisions so that we could contest these cases without any worry in our life. Today in the present video, in the present lecture series, I am going to discuss the important judgment of Honorable Supreme Court, whereby the Honorable Supreme Court quashes the entire proceeding against the registered medical practitioner who has been booked under the various provision of Drugs and Cosmetic Act. So we have to understand what the law is governing the concerned registered medical practitioner. We have to understand whether a common man could be booked, and we have to understand what will be the violation and what will not be the violation. So this video is quite important for the registered medical practitioner, for the doctors who are having the same problem. So let's start topic. Please have a pen and copy with you, because whatever point I am going to convey you, please note down the same, and this video will definitely provide you the pathway to proceed further in the right direction and to fight with these type of bogus and fictitious litigations. So start the presentation. Friends, the present judgment is passed by Honorable Supreme Court. In this case, the proceeding initiated under section 18C and section 27 subclause B, subclause 2, it is in Roman, has been quashed. So we have to understand the basis of facts, the basis of law, and the conclusion of the court. The appellant had moved before the Honorable Supreme Court because at the first instance she moved before the High Court and prayed to quash the proceeding, but it is refused. And ultimately she has filed SLP. You must understand, SLP criminal. And finally it has been admitted and it has been converted into a criminal appeal. And finally the appeal has been disposed of and the proceeding has been quashed. Easier to get, no? Now we are coming on the point. The appellant is a registered medical practitioner who is presently working as associate professor and head of dermatology in a concerned department. Previously, she held the post of assistant professor and civil surgeon. Basically, we could conclude that she is a registered medical practitioner. The case of prosecution is that she, in her individual and independent capacity, was carrying the medical practice at the premises specified in the consent complaint, and also it is specified that she, while doing the consultation, while doing the meeting, while doing the examination, prescribing the drugs written by her in the premises occupied by her, which is illegal because she is not having a valid drug license, and the same is violation of section 18 subclause C of Drugs and Cosmetic Act. So it is a very clear case. The inspection was done by the inspector, and inter alia he found certain medicines And finally, he booked the concerned accused appellant in the present case. Agreed from the same, the concerned appellant had moved before the High Court, but the High Court refused to quash the proceeding. Finally, she moved before the Honorable Supreme Court. She emphasized on the following legal position. First, on Section 18, she emphasized that the manufacturing for sale, distribution, sale, stock, exhibition, or offer of sale of the drugs are prohibited until the concerned person is having the license, and the concerned person, if having the license, is not contravening the condition of license. Both things should be certified. If it is not, the same would be an offense of Section 27, subclause B, subclause 2, because doing the business of the concerned medicines means the manufacturing, the sale, the distribution, or the stock without a license is an offense. In the present case at hand, it is not the case of prosecution that she is having a shop and she is doing the same from the shop. Rather than they are having the case that she has occupied or written the medicine in the premises from where she is doing the medical practice. The court observed that the key point is that certain rules are made for the protection of the medical practitioner, and specifically rule number 123 of drugs and cosmetic rules, which specified that as per schedule number K, entry number 5, certain drugs could be supplied by a registered medical practitioner without any violation or legal impediment. And the case of concerned petitioner appellant inter alia cover in entry number 5 or rule number 123, and while making the entire observation, the court observed that although it is an offense that if a person is having the medicine at a premises without a license, or if having the license selling the same in violation of the condition, but the concerned person who is a medical practitioner retaining the medicines as per entry number 5 of schedule K of rule number 123 of drugs and cosmetic rules, in that scenario it could not be said to be a violation. In that scenario, the prosecution totally failed to stand the case even beyond a doubt, even on prima facie level. The High Court should consider all this condition, because the power available to the High Court as per section 482 of CRPC should be exercised, although it is ruled that it should be exercised sparingly, but it doesn't mean that it should not be exercised. It should be exercised when on the basis of perusal of the uncontroverted facts, no case is made out and the proceedings are abuse of process of law. The court observed that in the present case, as far as rule number 123 is concerned, entry 5 is concerned, schedule K is concerned, she is not having any open shop, or she is not having the sale across the counter. Rather than she is keeping the same in the small quantity in the premises from where the profession of medical. So in that scenario, it could not be said that she is the violator. Apart from that, when she has been served with show cause notice, as per section 18A, she has specified the name of the concerned pharmaceutical shop from where he has obtained the medicine in bona fide. And apart from that, when the drug has been testified, it is found to be of standard quality. So the entire case is that she has stored the medicine without having a drug license. It is not a case of adulteration or substandard good or misbranded goods. So looking to the fact and circumstance, the court specified that if she is returning the concerned medicine as per entry number 5 of schedule K of rule number 123, and inter alia the same is in the small quantity, it is uncontroverted fact that she is a registered medical practitioner. In that scenario, she could not be prosecuted. So all these things should be specified in the sanction order, but sanction authority has failed to apply its mind, and it is indication that the concerned sanction authority has failed to apply the mind, and inter alia the present prosecution has been resulted. So the court found the same in contravention of law, and inter alia ordered for questioning of the entire proceedings. So friends, now it is easy now. If you are a doctor or a registered medical practitioner and inter alia you are going to be booked, just rely on this citation, and inter alia it will give you a best pathway to resolve your grievances. So friends, if this video enlightened you, inter alia it boost up you, and inter alia it encourage you to fight in the legal way. So friends, I think that it is easier now. If you are a registered medical practitioner, there is no need to worry. If you are inter alia booked in such type of case, this guidelines will be totally helpful to you. So there is no need to worry, just work out on your case, and you may also file the discharge, and even you could move for the questioning of the proceeding. Friends, see you in the next video. Till then, Jai Hind, Jai Bharat.